The following program is suitable for general audience of any age.
Tonight, we discuss the legislature surrounding employment and termination in the Sri Lankan context. What laws govern employees' rights in these grounds? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty here on Other Derana News Channel, where we bring to you key legal concepts and break it down for the layman. Today's topic is quite important when it comes to each and every one of us involved when it comes to employment, specifically not just those that are watching at home but also on the other side of the screen. Everybody is employed in some capacity, and it's very important for individuals to understand what their rights are as to the law relating to employment and also specifically termination grounds as well. So to speak about this program, speak about this topic, a very vast area, but we're going to try and trickle it down to the absolute basics for you. We have someone that is not a new face on the program, and we're very much excited and glad to have her back after quite some time. Thank you very much, and it's a pleasure to have you, Ms. Manoli Jinadasa, attorney at law. It has been quite some time. Thank you for coming to the studio to try and explain this very complicated topic in the simplest and most understandable forms for the layman.
Thank you, Andrade, and thank you for having me today.
It's always a pleasure. A little bit of an introduction to Ms. Jinadasa. She has been an attorney in practice when it comes to labour law for an extensive amount of years, and also very notably she is a part of the review committee for labour reforms for this current government as well as previous governments, and also she was a co-chairman for the Bar Association Standing Committee for Labour Law, specifically in the years 2022, 2023 and 2023-2024. So safe to say we're in very good hands when it comes to understanding the depth of the law in relation to this specific area. How we're going to be approaching this topic is quite simple. First, we'll be getting into the fundamentals, where exactly the law lies. Next, we'll be getting into the current context and the practicalities aspect of what exactly it looks like on the ground for the employer and the employee. And finally, we'll be talking about the remedial aspect for both sides of the coin.
Hello, my name is Amayuru Bandar and I'm a preliminary student at Sri Lanka Law College. So my question is on fundamentals. What laws govern termination of employment in Sri Lanka?
All right, well, without any further ado, let's get right into this topic. Thank you very much once again, ma'am. This is quite a convoluted topic, a very complicated area for laymen to understand, but we appreciate your effort in trying to help simplify and help us understand as well. But before we get into the practical aspects that might be more relevant to the viewer and you and I want to ask you about where exactly the law lies when it comes to the area specifically relating to termination as well as EPF and ETF, which is going to be one of the cruxes of this discussion. Can you tell us exactly where the law lies in this sense?
Okay, as far as the terminations are concerned, there's basically two types of terminations. That is the disciplinary terminations, where you terminate a person for misconduct, and then there is the non-disciplinary terminations, where sometimes if a company closes and you have to lay off people and there is no opportunity to recommence the company, one can apply to the Commissioner of Labour and terminate that person. Sometimes a person is not efficient, where you recruit a person and then you find that person does not suit the job. So then it's not a disciplinary termination, it's a non-disciplinary termination. So there are two types of termination that we can broadly categorize the termination of employment into, and that is disciplinary and non-disciplinary terminations.
Yes, and ma'am, on a related note as well, before we get into the specifics relating to terminations, when it comes to EPF and ETF funds as well, where exactly, what is the law that governs that area?
Okay, as far as the EPF is concerned, the Employees Provident Fund Act strictly governs the EPF payable to employees, and the ETF, which came in 1980, that is a Welfare Act, where the employer has to pay 3%, and that also governs. But in addition to those two, there is also the Gratuity Act, where on a termination, a person who has worked for more than 5 years is entitled to gratuity. So all three are Social Security Acts, and all three comes into play when it comes to a termination of employment.
Yes, and a question of curiosity that arises is how exactly these areas of the law interact with each other. Now, specifically, as you mentioned, when it comes to termination as well, the Gratuity Act is relevant, but also there are the standalone, the strictly governable ETF Acts and EPF as well. How exactly do these laws, specifically under the umbrella of labour law, interact with each other?
They are very consistent in most parts, I would say, because the Industrial Disputes Act and the Termination of Employment of Workmen Act basically governs the termination of employment of employees. Having said that, there is a sector, Anuradhi, which is forgotten, and those are the trainees. There is an Employment of Trainees Act in the private sector, which lays down the law and the criteria for termination of trainees, because the Industrial Disputes Act and the Termination Act does not apply to trainees. Then apart from that, although the Industrial Disputes Act covers domestic employees not so much specifically but indirectly, there is an old act in 1865. There was a Service Contracts Ordinance which had never been repealed. Now in that act there is a procedure for the termination of employment of domestic servants. It's called servants in the act, and that's why I'm applying that, referring to servants, and also journeymen and artificers, which are skilled labor. So there is a particular procedure where they talk of a 1 month payment of salary and discontinuation of service. And that is a forgotten act as far as Sri Lanka is concerned.
Yes, exactly. We tend to overlook it's not just employees of large corporations, but also domestic workers, as well as you mentioned, journeymen and other skilled labor workers as well. Now, specifically relating to, I think that's a very important point that you pulled up as well, ma'am, that the fact that we do have laws that do protect some of these individuals that could be considered of a vulnerable class. When it comes to unfair dismissals or unfair termination aspect of it, this is a very contentious topic when it comes to the public perception as well. How exactly do the principles of labour law help not just to protect employees that may be undergoing such a termination, but also balance the rights and abilities of the employers considering the termination?
With regard to unfair terminations, when one speaks of unfair terminations, once again it can be disciplinary or non-disciplinary. So as far as the main act, I would say, which comes into play in industrial law is the Industrial Disputes Act. That has several forums where the employee who feels discriminated or unfairly terminated could complain to. But what is very interesting in the Industrial Disputes Act is, with or without a complaint, the Commissioner of Labour has the power to intervene in any industrial dispute. And what is defined as industrial dispute, it's a very large definition. It includes termination of services. So there is also a possibility for the Labour Department to directly intervene in any termination of services in Sri Lanka of any employee. So the powers are very wide. Apart from that, under the Industrial Disputes Act, you get several forums, the Labour Tribunal leading the way, where within 6 months of any unfair termination, whether it's disciplinary or non-disciplinary, one could complain to the Labour Tribunal. If you miss that 6 months, sometimes employees realize that they have been unfairly dismissed later on. Still, you can make a complaint to the Department of Labour, and then if there is merit in such complaint, it is referred for either arbitration or at times, if the matter is of very importance, like large number of workers, sometimes to an industrial court. Now that is the disciplinary. For non-disciplinary, strictly non-disciplinary terminations, you get the Termination of Employment Act, where an employer also could apply, but an employee also within 6 months apply for non-disciplinary terminations.
I want to get specifically a little bit deeper relating to the distinguishing, as you mentioned, even the authorities that we can report to when it comes to the types of dismissals have a preference and a difference relating to if it was a constructive, unlawful or lawful termination. Can we delve just a slight bit deeper into the distinguishes between unlawful termination, lawful termination, as well as you mentioned, a constructive dismissal as well?
Yeah. So a lawful termination is a termination where there's a valid reason for the termination of that employee. And number two, there is a process that had been followed, giving a fair opportunity to the employee to state his case. And also the termination itself should be lawful, in the sense that in terms of the law. So that would constitute a lawful termination. An unlawful termination naturally would be the opposite of that, where you have not been heard, you have not been given an opportunity to state your case, and you have been terminated for grounds which are unfair. Now, apart from that, for a non-disciplinary termination, sometimes the employer decides that not to close down the entire company, but a part of the company or a segment, or he doesn't like your face and he wants you out of the company. That happens. Discrimination happens. And he says you're no longer required for this job. Now, that is a non-disciplinary termination because you have not done anything wrong, but the employer and you have some problem or the other, you don't like each other, and he wants you out. Now, in such a case, if he has not got your consent to terminate your service, it's always possible to mutually part ways by the payment of some gratuity or ex gratia payment. But if it does not happen, you have a remedy of complaining to the Commissioner of Labour. It can be either to the termination unit. There's a termination unit in the Department of Labour, so you can forward your complaint there, or you can make a general complaint to the Labour officer saying that your services have been terminated. And the Labour officer will go into that matter. He'll first try to settle the matter between the parties, and if not, refer it to the termination unit to process. And if the termination unit finds that your job is still required at work, but you have been unfairly dismissed, they will reinstate you. They don't just award compensation. But if they feel that the employer has a point and this job is no longer required for his company, he has been made redundant, then of course there's a formula in place in law, and according to that formula, depending on the number of services that you have had in that company, a compensation will be awarded by the Commissioner of Labour. That is for non-disciplinary terminations.
That's a very important point, specifically relating to the fact that there is a deliberation that goes forth in order to ensure that this redundancy that was made is not just out of the employer's grounds, but also considering the entire context. That leads me to the next question, ma'am. The concept in labour law relating to a just and equitable cause to determining a termination in order to ensure that it's a legal termination. If we can have a little bit more insight into what exactly that process is and how that concept actually functions in practicality when it comes to Sri Lanka's labour law context.
Yes. When you talk of justice and equity, that is, you are talking about mainly about reasonableness, because most courts look whether the employer's conduct had been reasonable and justifiable. So that is the concept of justice and equity, and that concept is a unique concept because the contract of employment, the terms and conditions that you have agreed upon between parties at the commencement of the employment does not come into play in a just and equitable jurisdiction, because they say that the employer has had an unfair bargaining position at the commencement of the offering employment, so he has the discretion to put whatever conditions of service in the letter of appointment. So the letter of appointment is not considered at all when it comes to the justice and equity or just and equitable jurisdiction. So the Commissioner of Labour or a Labour Tribunal President or the courts of law in this country, including the Supreme Court, will look at both the employer's side and the employee's side, and they will see whether the employer has acted reasonably. If he has acted reasonably and such termination is within the law, now what is reasonableness? Reasonableness is adhering to principles of natural justice. For example, if a workman is caught stealing something, he is in possession of goods, you can't directly terminate him because you don't know under what circumstances he is in possession of those goods. It may well be that somebody has introduced those goods to his bag. So it is always better to first either show cause him, investigate the matter, and then take a harsh line because stealing from the employer is clearly not acceptable and it's considered as a very serious misconduct. Now, on the other hand, I'm just giving you another example. Let us assume that there is an employee who is demanding a bonus. Now, bonus is something which is not an entitlement. It is at the sole discretion of the employer. He is unfairly asking for a bonus and not reporting for work. When we ask him to report for work and we order him to report for work, he is saying, no, until I'm given this much as bonus, I'm not. Now, the misconduct is manifest. The employee is ordered to report for work, he is not reporting for work. Then you don't have to go into the process of again adhering to principles of natural justice and showing cause. You can immediately terminate his services because he is refusing to adhere to the orders of the company and his demand is unjustified. So there are many situations like that, and there is no rigid rule when it comes to justice and equity. It depends on how the court assesses it and decides whether it is reasonable or not.
Yes, that's along the line that we want to go into, specifically relating to maybe practical applications when it comes to the court process as well. I want to get a little bit more information relating to that, but we have come to time in this segment, so we are going in for a short commercial break. You're watching Law, Land and Liberty. We'll be right back with the following segment. Stay tuned.
Hello, I'm Vinod Gorakapitiya. I'm a law student at Sri Lanka Law College. My question is on practicalities. How effective are the EPF and ETF laws in Sri Lanka?
Welcome back to Law, Land and Liberty. We're in conversation with Ms. Manoli Jinadasa, attorney at law, relating to the areas of termination and also EPF and ETF funds when it comes to labor law in Sri Lanka. We just got done with a very comprehensive first segment that lays down where exactly the law lies. Thank you very much for that, ma'am. I believe we got as much understanding to the context as possible. But before we move into the specifics that I wanted to get relating to the practical aspects and on-the-ground situations, there is one area that I want to draw a little bit of focus into, which is part of the terminations that we previously mentioned as well, that is on constructive dismissal. Now, we were able to understand exactly what the distinguishes is relating to lawful and unlawful termination, but can you give us a little bit of an understanding into what constructive dismissal is in the legal sense?
Yes. For a constructive dismissal to occur, there has to be a material breach of your contract of employment, because we see a lot of the times for a very minor dispute between the employer and the employee, people claim constructive termination. Now, for example, if you have been promised a salary and you're doing the work that you are entrusted and the salary is all of a sudden reduced, that would be a major breach in your contract of employment. Then you can claim that you have been constructively terminated from services after giving the opportunity to the employer to rectify the mistake. But on the other hand, let's assume you're in a transferable service and you are transferred all of a sudden due to exigencies of services. But your son is doing his O-levels that year. You don't want to move to another province. And you say this transfer is unfair, and you say, no, I feel that I'm constructively terminated because I'm inconvenienced by this transfer. Now, that would not constitute a constructive termination of services, or a minor dispute between the employer and the employee where they have a disagreement and they are a little angry with each other. These things occur all the time in employment. One day you are angry, next day you are the best of friends. And then you claim, no, he didn't speak to me nicely, I consider myself constructively terminated. Now, that is not constructive termination at all. Definitely, if there has been a dispute, that has to be resolved, but that would not constitute a material breach of the contract of employment. But if you have been promised emoluments and they are not given to you, or if you are demoted you are being taken for a particular position and then you are given a lesser position. All of a sudden you are given duties which you cannot do or which you should not do as per your position. Those are duties of a lesser post. So something like that would be very serious because it in effect demotes you, and then you can claim constructive termination. So always the principle is that it has to be a material breach of the contract of employment.
Yes. A very important point that you mentioned in the previous segment as well, ma'am, that is relating to where exactly the protections lie when it comes to individuals of various calibers when it comes to the termination of employment. You mentioned trainees as a very important point as well. I want to focus a little bit on that aspect now. When it comes to the practicalities of being employed, obviously there's going to be a process before one is fully entrenched in maybe a company or an enterprise of sorts. Can you tell us a little bit more relating to what measures probationary employees or trainees, people of a less of a permanent nature, when it comes to the protections that are awarded to them, what exactly does it look like with labour laws in Sri Lanka?
Anuradhi, let me first distinguish between a probationer and a trainee. Under the Employment of Trainees Act, a trainee is a person who comes into employment for 1 year for a training period, and then he is paid, he or she is paid a allowance for that training. Now, where the termination of a trainee is concerned, that can occur for disciplinary reasons immediately, or if otherwise you have to apply to the Commissioner of Labour, and with the Commissioner of Labour's permission you can terminate that employee on the basis that that person is not meeting the standards required of a trainee. He is not trained properly, or he is not understanding the work. So on that basis you can terminate. That is the only 2 grounds referred to in the Employment of Trainees Act. Now, a probationer is a little different. Probationer need not necessarily be a trainee. He can come from another employer to work for your company, and he can be subject to a probation period to see whether he or she is a suitable person for that job, and also a suitable person for that company, the company culture, whether he fits in with the others, because a company has to be run in a smooth and efficient manner. So any person coming, it's not only the work standard but the attitude of work as well. So a probationer can even be a very senior officer who joins, can be subject to a 6 months or 12 months or probation period. Generally it's 6 months. Some companies want a probation period of a longer period, which is justified sometimes, because sometimes the performance will only be seen after a few months, not within the first 6 months, especially in sales and so on. So therefore, sometimes for some jobs the probation period is 12 months. So for some jobs it's 6 months. In the state sector, sometimes it goes up to even 2 years, depending on the kind of title that you're going to hold. So a trainee is a person who's trained in a particular field, whereas a probationer can be any ordinary employee who obtains employment with a new employer.
So does that mean now that, as you mentioned, when it comes to trainees, the grounds for termination is far different to a probationary officer, but does that mean there's more added permanence when it comes to a probationary officer, as you mentioned now?
Yes, probationary the period of probation is there in most contracts of employment of permanent employees, and the termination of a probationer is a very controversial subject, I would say, because there are many schools of thought. Now, in general, most of the Supreme Court cases have held that when it comes to a probationer, one need not have the same standard that you would adopt for a permanent employee who had been confirmed in service. If the probationer does not meet the standards, or if you feel that he doesn't suit the employment, you can terminate him. But in the recent times, there have been judgments which specifically say even a probationer must be given, first of all, the opportunity to correct himself. So there has to be evidence that you have given him that opportunity by either advice, emails, or written communication. and he has to be assessed in his work. There are two particular judgments of the Court of Appeal in the recent times. One is Lanka Canaries case, and the other one is just give me 1 minute, I think I have it on. I remember.
So there are recent judgments as well.
Very recent. There was a very recent of M-Body Trading Private Limited, where the Court of Appeal and the same judge, he said there are 3 criteria. One is that you have to inform the person and you have to give guidance during the period of probation. Then if he is not performing satisfactorily, you have to notify him of that and maybe have an assessment process. Then there is a third step which is mentioned in the 2 judgments, which is a little controversial. That is, they also say that you have to apply under the TEVA Act, that is the Termination of Employment Act, and get permission of the Commissioner of Labour even for probation. Now that particular step has been subject to much discussion, because under the TEVA Act, one does not have to apply for permission to terminate an employee if the employee has served only less than 180 days. So 180 days is 6 months. So obviously the intention of the legislature was to keep the probationers away from the Termination of Employment Act. Secondly, the formula that has been gazetted by the Commissioner of Labour also, it gives compensation only from the first completed year onwards, which also buttresses the position of most juries that the TEVA Act does not apply to probationer. So it is generally said that the judgments should interpret the law and not rewrite the law. So that third step is subject to controversy, but I think those 2 judgments are salutary in the fact that they say that you have to inform the probationer of the duties that he has to perform and train him to a certain extent, and also you have to inform him of his shortcomings, because most employees sometimes leave another good job and joins a new employer in the hope of long and continued service. So after 6 months, if you are sent home, then you have lost a good job and you have your future prospects are also diminished. So the first 2 steps in those 2 judgments, I would say, is salutary, and much thought should be given into improving our laws with regard to probation.
Yes, I want to get to the reforms and amendments aspect as well, maybe later on into the discussion, what suggestions we can see with your practical experience in the field as well. But before we get to those specifics, I want to ask you specifically relating to the process, the court process that is undertaken when it comes to the hearing of these kinds of cases, specifically when it comes to termination that could be based on misconduct as well. Can you explain to us or help us understand what exactly the process looks like when it comes to moving to the courts in order to get a proper maybe justice on the employee's end or the employer in order to prevent any sort of misconstruing happening? How exactly does that work? And also, on a related note, what exactly are the steps that maybe the minimum number of steps that employers have to take when it comes to just considering termination as a whole, because it's not a simple one-step issue, as you mentioned as well.
So if we confine ourselves first to the disciplinary terminations, an employer who finds that an employee has misconducted himself must first of all write to that employee and inform him that he has supposedly committed this misconduct, and ask him to show cause. Sometimes it's not a formal show cause, sometimes it's asking for explanation. And on his explanation, sometimes if the misconduct is very obvious, one can straight away take disciplinary action. But the normal procedure is, when we find an employee has misconducted themselves, we initiate what is called a preliminary investigation, where the employer collects all of the facts relating to that incident, sometimes statements from other employees, and then decide whether there is sufficient cause for that person to be show caused. And then we send a show cause letter, and he is given an opportunity to reply to the charges against him. Then on those charges, there are 2 courses of action that you can take. If the explanation is absolutely unacceptable and there is sufficient grounds which demonstrate on a balance of probability that he has committed such misconduct, and the company procedures, because most companies have human resources manuals with a procedure laid down. And if the company permits that immediate termination or immediate punishment, it need not be termination, but as we are today talking about the terminations, I'll go into terminations, whether to terminate or not, one can take a decision. If the matter is not so simple, it's a little complicated, the reply is there, but there are certain gray areas in the reply, and the company feels that we have to look into this matter further, then the employer would have what is known as a domestic inquiry, where they get an independent inquiring officer to visit the company and have a domestic inquiry, which is similar to a formal court case actually, where the employee can present his side of the story and the employer can present theirs, and the independent inquiring officer will give the company a recommendation as to whether the charges are proved or not. It is the company who finally decides the punishment. It is not the domestic inquiring officer. What the domestic inquiry officer will basically tell the company is, yes, according to the evidence presented, the employee has committed misconduct, or sometimes they say, okay, there are some charges which are proved and some are not. In some cases they say there's insufficient evidence to form a conclusion. So then it is in the hands of the employer whether he wants to terminate or whether he wants to go for a lesser punishment. So then you if he is of the opinion that you need to terminate the employee, he can go ahead and terminate. Within 2 days of such termination, the employee should be notified that it is a disciplinary termination, and generally for what charges that he has been found guilty. That requirement comes not under the Industrial Disputes Act, that requirement is set out under the Termination of Employment of Workmen's Act. And why it is set out there is, that's how you distinguish a disciplinary termination from a non-disciplinary termination, because under the Termination Act, you can only go for non-disciplinary termination. So the definition is found in that act.
Yes, and before we go in for a break, I understand that we wanted to get a little bit more information in relating to EPF and ETF, but unfortunately termination is quite the vast area. Before we head into a break, ma'am, can you help us understand very quickly the obligations when it comes to EPF and ETF? Now, if we can get a bit of an understanding specifically, not just relating to what happens in the case of termination, but also where exactly the timelines lie when it comes to the strict nature of EPF and ETF as well.
Now, the EPF Act is a Social Security Act, and that is the only act which provides, the ETF Act is a welfare act, the EPF Act is the only act which provides a retirement nest egg for the employee. So, no employee, whatever misconduct the employee has committed, even if he has vacated his post or any other misconduct, the employee is always entitled to his EPF. Nobody can take away the EPF that has accumulated on behalf of that employee. So is ETF. ETF is a welfare act where when you leave employment of one employer, you can collect it, and after 10 years, if you can again withdraw when you go and join another employer. So both EPF and ETF cannot be touched by the employer, so to speak, that he can't recover any losses caused by the employee. He cannot hold back the EPF or the ETF on the basis that this person has committed a misconduct. Every employee is entitled to EPF and ETF. It has to be paid within, generally any EPF you only collect when you're 50 for a female and 55 for a male. But while in the course of employment, employer must pay EPF every month, and that has to be paid within 1 month, before the end of the succeeding month. Say you're entitled to your salary on the 30th, before the 30th of the next month, your EPF and your ETF has to be transmitted. If the employer has defaulted in the payment of EPF, there are very strict penalties. And there's a very interesting point, because a lot of employers assume that if the employee and the employer consents not to pay one's EPF, not to deduct EPF, ETF, then there is no payment obligation because the employee has in writing consented that he need not be paid his EPF, ETF. That written document has zero value because it's an obligation in law, and section 15 says of the EPF Act that the obligation to collect the EPF component contributed by the employee, because EPF is a contribution by both the employer and the employee. So it is the obligation of the employer to collect the EPF on behalf of the employee as well, his portion as well. So if it is not collected, then the employer is liable to pay both portions. That's the full 20%. Normally it's a 12% and 8%, but the full 20% has to be paid by the employer if the EPF and ETF is not paid. May I quickly get into the timelines?
Yes,
because you asked me. So if it is from the due date, if it is not paid within 10 days, there's a 5% penalty. Then between the 10th day and the 30th day, if you have not remitted, there's a 15%. Then from 1 month to 3 months, it's about 20%. 3 to 6 months is 30%. 6 to 12 months is 40%. And after that, there's a 50% penalty on the EPF. Now, the drawback of this is the Act does not provide. Now, supposing a person is terminated and his EPF is not paid, 1 year lapses. After 1 year, if you recover it, it's a maximum of 50%. It doesn't go beyond that. So the longer it takes, it's a benefit for the employer because the penalty stops at 50%. I believe at present the Labour Department is looking into this matter, and I am reliably informed that they are going to rectify this deficiency to ensure that the employee is paid fairly his EPF and ETF in a timely manner.
Yes, a very important point there relating to what we can see as future developments as well when it comes to the existing framework that we have. Unfortunately, we have come to time in this segment. We do have to go in for a short commercial break. Please do stay tuned as we'll come back with the final segment on Law, Land and Liberty here on Other Derana News Channel. Stay tuned.
Hello, I am Taradu Singh from Sri Lanka Law College. My question is on future. What we can expect as a reform to the labour laws?
Welcome back to Law, Land and Liberty here on Other Derana News Channel. We're in our final segment in conversation with Ms. Manoli Jinadasa, attorney at law. We just got done speaking about the current context and the practicalities relating to termination of employees as well as EPF and ETF funds and their practical application as well. Unfortunately, it is quite the vast area, therefore we are not able to cover the entirety of these acts and also the legal processes relating to it and the rights that are owed by employers to employees, and also vice versa, the rights that employers have when it comes to protecting corporations as well. Ma'am, thank you very much for the previous 2 segments. Unfortunately, we are running out of time in this segment, so we won't be able to touch any further into the depth of the law. But I think a very important point that I wanted to draw attention to is relating to the reforms aspect, the amendments aspect. Now, with your experience as well, being part of the Reforms Review Committee also, there is a conversation going around whether there are active reforms being made to these legislations, whether it is actually constructive in its sense, or is it just a means to an end? What do you think it looks like right now on the ground, ma'am?
In labour legislation, there are about 31 acts. Only about 15 or 20 are subject to reform right now, and those are the important acts like the Industrial Disputes Act, the Termination of Employment Act, and most importantly the Shop and Office Act. I can't go into too much detail about the ongoing reforms as its process is on, but there are so many aspects of employment that have not been covered previously, like for example part-time employment, working from home, then gigs where you have short employments, and now the young generation, they like to be independent, so they like gigs more than permanent employment for a long time. So there are several aspects like that that will be touched upon in the reforms, and the reforms will try to codify and simplify the law, because we find that with 31 acts in process, human resources management and also foreign investors find it a little difficult, especially the Wages Board Act. Under the Wages Board, there are about 41 wages boards in town. So they are trying to amalgamate and have a common set of terms and conditions and service conditions for employees, and only deviate from that common unit for specific industries where certain exceptions have to be made. So the reforms are very positive, and very recently we read the ILO paper on sexual harassment was ratified by Sri Lanka, and the reforms will touch upon sexual harassment as well and have separate chapter on sexual harassment as well. But the reforms are ongoing, so I would rather not talk.
Keep it under wraps.
Yeah, keep it under wraps.
Until, of course, it will be
Yes.
publicized, and the general public will be
Yes.
able to, maybe in the future we can do
Yes.
a bit of a follow-up as well
Yes.
relating to that.
And what we are doing right now is reviewing the reforms, because reforms is it's a government endeavor done by the Department of Labor. But there are quite a number of people involved in the reforms, and hopefully we will be able to have a simple labor legislation in the country which will work for everybody.
Yes, ideally, while implementation is going to be the biggest issue, in order to facilitate that, we have to ensure that the practical applications are much more easily accessible as well. Before we end off this discussion, separately relating to the grounds of EPF, ETF, and also termination, drawing from our previous conversation, ma'am, do you believe that the currently existing pieces of legislature that are there for termination and also for EPF, ETF, are they sufficient and wholesome, or do you believe there are lapses that need to be immediately addressed?
Yes, where termination is concerned, the labour tribunals are functioning quite well. But I must say the arbitrations, because there's arbitration procedure as well, we need to have set of rules for arbitrators to appoint qualified arbitrators who know the subject to hold arbitrations, because right now arbitrators are appointed by the minister, and while some of them know the law, they're lawyers or ex-presidents of labour tribunals and so on, in the recent times there had been a trend to obtain the services of non-lawyers. So sometimes the principles of natural justice, how evidence should be led, how the process should be implemented, you need experience, and they don't have the experience in the law, and that is very much necessary in the arbitration process. The labour tribunals have generally functioned very well in Sri Lanka. It is this other process that has to be looked into. And the Labour Department, while the Labour Department plays a huge role in industrial law, they have inquiries. Even inquiries for EPF, ETF is handled by Labour Department. But unfortunately in Sri Lanka, there is no streamlined procedure for the holding of inquiries before the Labour Department. Now, I will give you a very small example. Now, when you have the Small Claims Court, there's a Small Claims Act, and there's a specific procedure, expeditious procedure to resort to in solving a small claims case. Now, the Labour Department for EPF, ETF, we deal with millions. The value is very high, but there is no process, a specific guideline or process in the manner in which a Labour Department inquiry is held. So that is something that we really need to look into, because especially the country is looking for foreign investors, they're looking for new employment, and employers are placed in jeopardy when there is no proper procedure. Employees also are placed in jeopardy when there is no proper procedure in holding an inquiry. So we need to formulate a specific procedure for Labour Department inquiries, and that is a big lacuna in the law we have at present.
Yes, and hopefully we can see that addressed in the future. maybe the next time we have a conversation, there could be constructive development relating to that. Before we end off this discussion, ma'am, I'd like to ask you now, specifically for the viewers that are watching this program, this was quite an extensive topic that we have tried to simplify and boil down to as much of a little capacity as possible. When it comes to people that are maybe in a situation, a specific situation relating to employment, termination, maybe relating to their employees' provident fund or the trust, is there maybe some sort of comment that you can leave them with relating to seeking legal advice and actually being well informed about matters such as these?
It is very important to take action in a timely manner. There are timelines that has to be followed by employees, and all of the details are there now with the internet. All of these acts, all of the details are there even in the Labour Department, and anybody who wants guidance can always go to the Labour Department first and foremost, because there are enough and more Labour officers who will direct you to the correct forum. They will say this is a termination based on misconduct, so go to the Labour Tribunal, or if not, they will say that you have to go to the termination unit for your in respect to obtain relief for your termination. So the Labour Department is quite active in protecting the rights of the employees. So if you go there in a timely manner, without delaying, I think you will be entitled to get your redress. As far as EPF and ETF is concerned, the machinery has been running very smoothly for a while. During the COVID period, there was a backlog, but I believe that backlog is no more. And those officers have been working very hard. They're very, very strict in the implementation of the law. The only lacuna I see, as I said, was the inquiry process. If we can improve that, I'm sure the legislation is more than adequate to resolve any problem.
Lovely. Unfortunately, that is the time that we have allotted for this program. We could go on and on relating to, as you mentioned, it's a very vast area, ma'am, and there are maybe separate areas that we can pick on in the future as well that could help individuals in certain situations be well and better informed as to their rights, and also what they could do in order to avoid any sort of misconduct or maybe lapses in the law as well. Thank you very much for the time that you have taken in order to come to the studio and explain this concept to us, ma'am. We appreciate it.
You're most welcome, and thank you for having me on the show.
All right, well, we'll leave you tonight with the words of Mariano Rajoy. We have to change economic policy, create confidence, foster investment, cut the public deficit, restructure taxation, and reform the labor laws. That's all we have for you tonight. You can always rewatch by catching us on our YouTube page, and we value your opinion as always. So please share your thoughts and feedback with us through email at feedback.adncenglish@derana.lk or via WhatsApp at 076 805 7933. Thank you very much for watching. Have a good night.